I want to show you what a real cover-up looks like.
When did the minister find out it was unlawful? Not when did he decide to do something about it or tell us publicly. When did the minister know Robodebt was unlawful? It's a date, Stewie.
As I've said last week in the House and this week in the House, as soon as I was informed, I moved expeditiously to inform the Australian people, and that date was the 19th of November. The government moved expeditiously once informed that the scheme was raising debts in an insufficient manner to pause all debt recovery.
The Coalition claims that they first found out that Robodebt was unlawful on the 19th of November 2019. Stuart Robert, the minister responsible at the time, said that as soon as he found out, he moved to pause the program and hold a press conference. This is that press conference, where he basically says they've made some refinements.
This morning my department commenced some refinements to the income compliance system. We make no apologies and we do not stand back from ensuring the legal obligations that the right people get the right money, and ipso facto ensuring that people who have been overpaid repay that debt.
The problem is that this press conference was 1 week before the government accepted in the federal court that the program was unlawful. The idea that the government moved immediately to stop Robodebt is rubbish. And in this video, I want to show you the layers of cover-ups that have tried to prevent the public from realizing that Robodebt was rotten from the start. But first, let's go back to 2017. As Robodebt was fully implemented, numerous complaints started flooding in, raising red flags that something was wrong. I'll go through this in a lot more detail in part 1 and part 2 of this series, links in the description. But the Coalition kept saying that everything was fine.
Well, Christian Porter is the Minister for Social Services.
So, from what we've seen, in a high volume system, it's actually working incredibly well. Now, there will from time to time, no doubt, be people who, for whatever reason, are experiencing difficulties getting online or having problems, but we're incredibly accommodating of those circumstances. Now, what this system is doing is actually raising real debts around real overpayments based on real cross-referencing of evidence.
Can you not see, though, why some people might find the whole thing quite terrifying?
Well, what you're saying to me, Hamish, is if people over-respond or if people find it inconvenient, that the response to that by a government should be to not do it. Now, if we don't do it, that is $4 billion worth of taxpayers' money that got wrongfully paid, that can never be recouped, and in incredibly difficult budget circumstances where we're trying to return the nation to surplus, we would have to try and find other ways to save that money. I think that this is about as reasonable a process as you could possibly devise.
That interview reveals the true motives. Too much money was at stake. The Coalition had promised $4 billion to be recovered, and if all of a sudden their method was being questioned, where would they get that money from? Very early on, legal experts were questioning the legality of Robodebt. Peter Hanks, a barrister with expertise in this area of law, gave strong warnings as early as 2017. He asked, does Centrelink have the legal authority to raise a debt in this way? He said that the existence of a debt to the Commonwealth is something that needs to be established by the Commonwealth as the entity who is asserting the existence of the debt. In other words, the onus of proof is on the government to show that a debt in fact exists. It can't just assert a debt based on dodgy assumptions and enforce them if the victim doesn't provide more information. And this is important. What the Coalition has done is deliberately confuse what people's obligations really are. It's true, people have an obligation to report their earnings at the time they are receiving Social Security payments. But no one's arguing with that. In the majority of cases, Robodebt victims did correctly report this information. It's Centrelink that failed to check this information at that time, and is instead coming back years later with flawed data comparisons and again asking for information that people may not be able to obtain. If you can't provide that information, then the government is pretending that you have failed your obligation and therefore owe a debt. The Law Council of Australia, the peak legal body in the country, summarised the issue, saying, it's not in dispute that people are under an obligation to provide information to Centrelink. That obligation should not, however, be conflated with the requirement to prove or disprove the existence of a claimed debt. Now, experts saying the scheme was unlawful is one thing, but having it tested and validated in court is something completely different. the government was desperate to avoid having a public verdict which would guarantee the shutting down of Robodebt. So it did what it could to make the process of appealing debt decisions as confusing as possible. In reality, there is no time limit to appeal a debt. But these letters sent to victims don't make that clear. In fact, I would say it's designed to confuse. The same wording appears on the review of a decision form. Time limits to review decisions appear in bold, but then further down it says there is no time limit. If someone did ask for a review, there were multiple stages they needed to go through. First, there's a review by a subject matter expert. And then, if you get past that, there's a review by an authorised review officer. If you want someone outside of Centrelink to review the decision, you'll need to go to the Administrative Appeals Tribunal, or the AAT. The AAT can review government decisions in a lot of areas, including social security. Think of it like an informal court. Two sides make their case, and a tribunal member makes a decision. The problem is that you can't appeal directly to the AAT until the internal Centrelink review processes have completed. And because of this, Centrelink has been keeping people in a loop of review so they give up and don't make it to the AAT stage. Even when someone did get to the AAT, there were issues. A Crikey article in 2019 exposed the fact that the AAT was calling people who had applied for an appeal of their Robodebts and was trying to convince them not to pursue their case. Sources said that these phone calls warned applicants that they didn't have enough evidence and that they should just accept the loan. This is despite the fact that many who ignored this advice and continued with their appeal ended up winning and having their debts wiped. But many took this dodgy advice and withdrew their applications. The 2019 AAT annual report said that half of the applicants contacted during this outreach stage elected not to proceed with their application. That's ridiculous. Half of these applicants who may have had their debts set aside were persuaded to give up. And this continued in later years as well. The 2020 annual report said a similar outreach program meant that half of those contacted chose not to proceed. It wasn't until 2021 that this practice was stopped. Not long after Robodebt was fully implemented, even with all the confusion, people started having their appeals heard in the AAT. And in a lot of these appeals, the AAT set aside the Centrelink debt because it was recognised that the debts had been unlawfully calculated. Unfortunately, these AAT decisions are kept hidden from the general public, and that's because they're what's called AAT1 decisions. I'm oversimplifying a little bit, but when these matters are first appealed to the AAT, they go to the AAT1 level. Any further appeals then go to the AAT2 level. AAT1 decisions are not made public, but AAT2 decisions are. This is important, and I'll come back to it. Because of the recent class action lawsuit and various Senate estimates, we've been able to obtain some AAT1 decisions that we otherwise wouldn't have seen. The class action identified 76 AAT matters that ruled that Robodebts relying on income averaging were unlawful. It would have been absolutely clear to the federal government, who kept losing these matters, that something wasn't right, and yet it didn't do anything about it. 5 of these decisions were made by Terry Carney, who was also a law professor specialising in social security law. The first of these was decided in March 2017 and related to a debt of $7,500 that the government was trying to recover from a former social security recipient from years ago. The victim had provided information on their earnings to Centrelink at the time, as was their obligation. But Centrelink had come back years later and asked for payslips and evidence that they didn't have a debt owing. When this couldn't be provided, Centrelink used income averaging as the basis for calculating their debt. Terry Carney, in his decision, said that the applicant no longer held payslips, and that there would be few citizens who do, especially given Centrelink's own website advice was only to keep these records for a short period of time. Quite simply, if Centrelink is unable to provide proof of the debt, then no debt arises in law. His decision was that no debt was able to be founded on extrapolations from ATO records. Remember, this was an AAT ruling as early as March 2017 that said that Robodebt was unlawful. Terry Carney made 4 other decisions against the coalition government. They followed the same pattern, but I want to go through one of the other decisions. In this matter, the victim was being chased for a debt of almost $10,000 because he couldn't provide relevant payslips from years earlier. The victim had been working for 8 different employers with irregular work arrangements. He had less than $200 in the bank, and his only asset was a motorbike worth $6,000. This was not someone sitting around doing nothing and abusing the system. And yet Centrelink, using unlawful assumptions, was attempting to recover a debt that was more than this guy's entire net worth. And again, the decision made it clear that no debt can be founded on extrapolations of fortnightly earnings. So we know that the government knew in early 2017 that AAT rulings were finding the assumption it was using to be unlawful. But as part of a cover-up, Centrelink didn't once challenge the rulings by appealing any of the decisions to the next level, AAT2. If the government had appealed the cases it lost to AAT2, the decisions would then become public, and Robodebt would have been blown wide open years earlier. So instead, they just accepted losing these matters, kept them hidden, and continued doing exactly what was being ruled to be unlawful anyway. Speaking of cover-ups, it gets worse. Terry Carney's last Robodebt decision in the AAT was on 7 September 2017. But then something happened.
The last one I want to do is regard to Mr. Terry Carney. You're familiar with his situation?
He's a former member of the AAT.
Yes, he lost his job at the AAT in late 2017. Now, media reports suggested he lost his job via a short, blunt email in September 2017. Is that correct?
I couldn't comment. We haven't received a copy of that.
Do you have a copy of that media report?
I've got it. Well, I've got it here somewhere. We'll get you if you feel that's necessary. But there's
If you're going to refer to media reports, yes, please provide those for the witness.
We'll find that out. Well, let me just, given we've only got a few minutes, let's just say that the Crikey report was Mr. Carney had a long career at the AAT, and together he worked.
Particularly given it's a Crikey report.
Well, what you mean to say that that's what, illegitimate? Is that the suggestion?
I mean to suggest that it's very important we ensure reliability.
Well, given the Liberal senator was suggesting that the media report was potentially inaccurate, let's have a look at the actual letter itself. Exactly 3 weeks after his last Robodebt decision, Terry Carney received this letter from George Brandis, who was then the Coalition's Attorney General. The letter told him he was fired. It is literally a few lines saying, "Your term has expired, thanks for your service." This is despite the fact that he had served at the AAT for around 40 years and was a legal expert in his field.
It's reported that Mr. Carney had worked at AAT and with his work on the Social Security Tribunal put in over 40 years of service. Is that correct?
I would have to check what his record of service, but he certainly was a long-standing member of the former SSAT as well as the AAT.
I understand that he is an emeritus professor of law at the University of Sydney. Is that correct?
I believe that's true,
That's right.
yes.
He even apparently had the endorsement of the president of the AAT.
Is it the case that the president of the AAT recommended to the Attorney General that Mr. Carney be reappointed?
I would have to take that on notice, Senator.
The official written response back to the Senate for that question was that there is a public interest in maintaining the confidentiality of this advice. I don't think they understand what public interest means. But this didn't stop Terry Carney. Instead, he has since been a vocal critic of Robodebt and the government's cover-up of the warning signs. He wrote a really good article where he said, by continuing to raise these debts in the knowledge of adverse AAT1 rulings, Centrelink acts unconscionably. As a side note, maybe you're wondering, the Coalition probably got rid of Terry Carney because they wanted to put other, more qualified people onto the AAT. In reality, the Coalition has spent its last few terms absolutely stacking courts and tribunals with Liberal Party mates. It's funny that the Liberals were bashing Crikey because they've done a great series into this. Look at this example. Donald Morris was appointed as a senior member of the AAT in 2016, with a term that will last until 2024. His salary is around $400,000 a year. Yet he has no legal qualification, not even a law degree. But what he does have is a career working for various Liberal Party politicians. And this isn't unique. The Coalition have appointed a bunch of people with limited or no legal experience into the AAT. How are those people meant to decide on complex areas of law? I guess that's maybe the point. It's such a joke that I want to do a separate video on it, so stay tuned. But let's get back to Robodebt. While AAT decisions were being kept hidden, in 2019, federal court cases, which are in the public eye, started popping up. But the cover-ups didn't stop. Victoria Legal Aid is an organisation which assists people with legal issues when they don't have the means to spend money on lawyers themselves. Organisations like this all across the country were getting swamped with Robodebt matters and were seeing the damage firsthand. And in 2019, Victoria Legal Aid decided to launch a test case to the Federal Court of Australia. The victim, Madeline Masterton, had received an unlawfully calculated Robodebt for almost $4,000. But within a week of the lawsuit being filed, Centrelink conveniently reviewed the debt and reduced it down to $600. When Victoria Legal Aid pushed on with the case and the first hearing date came around, the coalition asked if they could recalculate the debt again, and this time they came up with zero.
No, it's all fine.
After 2 attempts at asserting a non-existent debt, they got the right answer. The government then argued that because there was no debt, there was no issue for the court to rule on, and the matter stalled. This was yet another cover-up. Without a federal court decision, there would be no public determination that Robodebt was unlawful, and the program could continue as normal in the background. But then the government stuffed up. Victoria Legal Aid brought a second test case to the federal court, this time about a Robodebt received by Diana Amato. In 2018, the government sent her a letter demanding payment of $3,000. Because they had the wrong address, she never got that letter. But that didn't stop the government from adding a penalty of $291. Later that year, the government garnished her entire tax refund, almost $2,000, to pay part of the debt. Again, this was all without her knowledge. After the lawsuit was filed in the federal court, surprise, surprise, Centrelink reassessed the debt using information it found itself and determined there was no debt owing. But this time, Diana asked for interest. After all, the government had taken money from her for a debt that didn't exist, so there was a tiny amount of interest that would be owing, less than $100. And this is where Centrelink stuffed up. Instead of paying the interest and closing the case down like they had with previous test cases, they let this one go to judgment. And the federal court ripped Centrelink to shreds and ruled that the income averaging assumptions made by Centrelink were unlawful. The judge said the conclusion that a debt has arisen was irrational in the requisite legal sense. The government also had to pay outstanding interest and legal costs. What's mind-blowing is that after so many years, it took action from Legal Aid in the federal court to finally put the fact that this was unlawful into the public's view. This also shows just how important these kinds of organisations are.
So Joel mentioned earlier our client Diana Amato, who received a Robodebt of over $3,000. Now, if Diana hadn't sought legal assistance, it's pretty unlikely she would have put in an FOI request, which revealed ultimately that the calculations were incorrect, and she would have repaid that $3,200 she didn't owe and couldn't afford. We ran strategic litigation because that is an effective and efficient way of demonstrating the unlawfulness of the process here, and ultimately, results in a great outcome for thousands, hundreds of thousands of Australians who had received a Robodebt. So the role of legal aid and community legal centres, I think, can't be underestimated here, and it's a demonstration of the benefit of legal assistance in this context as well.
Days before this federal court decision, the government already knew which way it would go. And that's where that press conference with Stuart Robert comes into it.
This morning, my department commenced some refinements to the income compliance system.
If you remember, this was apparently the first point in time that he knew Robodebt was unlawful. Not when the experts were saying it, not when the AAT ruled it unlawful on numerous occasions, not when they tried to shut down the first federal court case. It was only apparently now, years later. Unfortunately for Stuart Robert, given how the coalition had tried to cover things up for so long rather than fix the problems early, there was more legal action still to come. In the same month that the federal court ruled Robodebt to be unlawful, a class action lawsuit was filed against the Commonwealth. This would become the largest in Australia's history. The law firm Gordon Legal, on behalf of hundreds of thousands of impacted Australians, sued the government on 2 main grounds. First, that the Commonwealth had unjustly enriched itself by collecting unlawful debts, and second, that negligence had caused economic loss and stress, anxiety and stigma. Gordon Legal submitted to the court that not only had immense damage been suffered by victims, but that the government knew all along that the program was unlawful. Faced with all of this, the government settled the lawsuit to avoid a messy trial. As part of the settlement, the court made declarations that debts using income averaging assumptions were not valid. This meant that $1.763 billion of debt would either be refunded or withdrawn. On top of that, an additional $112 million of compensation would be paid to specific victims, mainly to cover interest costs when money was falsely taken from them. This was a massive case, and the judge has some strong words to say. The proceeding has exposed a shameful chapter in the administration of the Commonwealth Social Security system, and a massive failure of public administration. The financial hardship and distress caused to so many people could have been avoided had the Commonwealth paid attention to the AAT decisions or had appealed them to a court so the question as to the legality could be finally decided. This has resulted in a huge waste of public money. I had a look at the defence the Commonwealth was trying to run with before they settled, and it had some interesting stuff. One argument they ran with was that they should be able to keep the money they had already recovered and just waive the amounts they hadn't. How did they think that was even a legitimate thing to argue? And then there was this. An earlier version of their defence document said that it was embarrassing to claim that people were unlikely to have retained or have access to the relevant records to prove they didn't have a debt. The only embarrassing thing is that this was written in 2019, after all the issues had already been exposed. Anyway, while the settlement was massive and a lengthy and costly trial was avoided, it meant that damages suffered by victims weren't taken into account, other than some minor interest costs that were to be refunded. This was very much a settlement that looked at the monetary costs and not the human costs of the program.
There was the $112 million supposedly for compensation. Could you just tease that out a bit more for me?
There has been no compensation for the harm that Robodebt has caused. And I mean, if you take the legal costs out of the $112 million that was part of the settlement, and apply that across everyone who was part of the class action, that's obviously a relatively small amount.
This isn't a criticism of Gordon Legal, the firm that ran the class action. They were doing what was in the best interests of the clients, depending on what would likely succeed in court. And there was a chance that some of the claims they were making would fail at trial. But this is exactly why we can't look at the class action and pretend the matter has been investigated and that there's been accountability. That wasn't the intention of the class action.
The class action could never have been and was not designed to be a royal commission or any kind of commission of inquiry with those kinds of powers into the conduct of the very senior public servants and various ministers of the government that oversaw the design and implementation of the Robodebt scheme. I must say that one of the concerns we had throughout the conduct of the proceeding is what we considered to be the Commonwealth making quite spurious claims of legal professional privilege and parliamentary privilege in respect of documents. And the record will show that there were very extensive court processes involved in persuading, and at times it required judges to make orders to coerce the Commonwealth to abandon some of the claims it made.
And that brings me to my next point. The coalition government, in both the court cases and Senate inquiries, has refused to provide all the relevant documents that would help in understanding what went on with Robodebt. A key question is, when did the government know Robodebt was unlawful? We know from emails obtained from the ATO that the coalition had legal advice saying that Robodebt was unlawful prior to the federal court decision which confirmed that fact. But we don't know what this advice contained and how long the government has been sitting on it. The final Senate inquiry report sums up the deliberate withholding of information. The committee has repeatedly requested crucial information from the government, but this has been refused on the basis that the release of information would harm the public interest. These documents could reveal what the government and Centrelink knew about the legality of Robodebt and the cost of government actions. The Public Interest Immunity Shield has been invoked numerous times. This letter says that the government won't release any information because it might jeopardise ongoing legal cases. Even if that was a legitimate reason, after the lawsuit's finished, guess what? another public interest immunity claim. This one said that while all the cases had now been settled, it's possible that in the future someone else might sue the government, so it still can't release the information. Despite this clear obstruction, former Prime Minister Scott Morrison had this to say.
Well, there have been numerous inquiries into this matter, and there's been court matters which we've fully cooperated in, and some almost 750 million in reimbursements have been made by the government, and the changes to the scheme have been put in place, so the problem has been addressed.
That's a complete lie. The matter has not been addressed, and that's why the final Senate inquiry report, handed down in May 2022, made the recommendation that a royal commission into Robodebt be established. This is what advocates have been calling on for so long now.
I mean, Robodebt went for close to 4 years before it was stopped, and that was only because of the federal court case. And we still don't know who knew what and when. I think that is why we need a royal commission or some form of independent inquiry that is at arm's length of government to get to the bottom of what happened. This is ultimately about restoring trust in government. People aren't trusting the debt recovery system, and why would you after what has happened? And that is also why it's important that we get a much fuller understanding of what went on than what we currently have.
Thankfully, with the coalition booted out of government, it looks like we may end up getting a royal commission after all. Labor has committed to setting one up this year, so we'll have to wait and see what their scope is and what comes out of it. In the meantime, let's never forget that the responsible ministers told us time and time again that everything was fine, when the exact opposite was true. Thanks for watching. If you want to help me make more content, please consider checking out my Patreon page, links in the description.